Just give me one moment. Go ahead, counsel.
Yes, Your Honor. Mr. King is gainfully employed, and as I said, while he was on bond for the previous case, he had no further issues. Numerous times we tried to get him off tether, and that was not successful. He has retained counsel, and immediately upon learning of the reissuance, myself and Attorney Jaffe set up a time for him to come in and do this walk-in arraignment. He has voluntarily surrendered. He does fully intend to appear for all future court dates, and I would ask for a personal bond.
And when was your client notified of the reissue, you said?
Mr. Jaffe got an email from the prosecutor yesterday afternoon and around 4 o'clock, yes.
And Your Honor, I do have notes saying that the defense counsel was arranging to have him turn himself in.
Okay, I read the allegations in this report. I'm going to continue the interim bond of $200,000 cash, 10%, but without a GPS tether.
I don't know what's going on right
Is that an affordable bond for your client? Otherwise, I'll set a bond determination for Monday, February 3rd, in front of Chief Judge McConicle.
Yeah, if we could get a bond rate determination here, you know.
Okay, I'll schedule that for Monday. Bond redetermination. Monday, February 3rd, 9 a.m. in front of Chief Judge McConicle. Probable cause, February 7th in front of Judge Jack Hay. Preliminary examination, February 14th. Also in front of Judge Jack Hay. No contact with Carly Render. While this case is pending, you also not to possess any handguns, firearms, or other dangerous weapons. Officers, where would you want him, Mr. King, to go? And counsel, you can wait for your client's paperwork. Okay, just counsel, just wait for your client's paperwork. Okay, Mr. John.
Good afternoon.
All right, Mr. Granger.
Yes, sir.
Okay, state your name again for the record.
Shantaz Granger.
All right. Ms. Douglas, didn't I arraign Mr. Granger in another case a little while ago?
Your Honor, Mr. Granger, yes, Your Honor. That was this morning, I think. Wait, no. I thought Magistrate Boyer did it.
Okay.
I think he'd sat in for you. And I think Magistrate Boyer did it.
Okay, gotcha.
But a
This
different
wasn't
case.
today, right?
No, this was yesterday, I think. Yesterday morning.
No. It was not today. But I remember his name. Just like I remember your name, Murad. You're unforgettable.
I think so too, Judge. I think you're onto something there.
Yes, Ms. Douglas is a little bit more memorable. I've worked with her longer.
Fair enough.
All right, appearances.
I agree,
Jennifer
Mr. Bowman.
Douglas for the people, P72748.
And Rad Murad, P83665 on behalf of Mr. Granger. We waive reading, stand mute. Mr. Granger's been advised of his rights.
Court will not guilty plea on behalf of Mr. Granger. Bond recommendations from the people.
Your Honor, on this case, the people wouldn't object to a personal bond, but we are asking for a higher personal bond, and we are asking for a tether. We believe that Mr. Granger is a flight risk. Your Honor, here there's allegations that he did try to flee from police after the police had stopped the car and asked everybody to get out, Your Honor. So we do think that's an indication of that there would be flight. And also, Mr. Granger just got arraigned on a 2016 case because of his most recent capias on that case, Your Honor. The original capias bond on that was 5,000 cash or surety. It got changed to 10,000 personal with a tether to ensure his appearance. And so, Your Honor, given that the only reason he was back in court on that case apparently is because he picked up this case. We didn't know he had this case when he got arraigned before, but we do believe that that indicates a established flight risk, and we are asking for a tether.
Isn't it, you said he's already on tether?
He's got a 10,000 personal tether and the other one.
Okay. Mr. Rod? Oh, I'm sorry, Ms. Douglas. What was the higher personal bond amount you were seeking?
Your Honor, we would ask for 35,000 personal bond. I would also note, and I don't know if Mr. Byrd had mentioned this to Mr. Murad, but I remember when Mr. Granger's case that Mr. Byrd indicated that Mr. Granger had missed court because he had a lot of things going on in his life, including the death of his father. And Magistrate Boyer asked when his father died, and he
I
said
remember that. It was
2006.
It was a very big discrepancy between the dates.
Yes, 2006. And then Mr. Granger said that he had actually called his probation officer in 2018, and she never called him back, even though he had left a message and everything, and that is why he never came back to court for the last however many years. So we do think there's a flight risk.
Go ahead, Mr. Murad.
I mean, if the court's inclined to just adopt the personal bond without a tether, I won't necessarily get into anything else.
Well, you know what, Mr. Rod? You know what, Mr. Rod? I'm going to adopt the recommendation of $35,000 personal bond. I don't see a need for a second tether in this matter. So $35,000. That's a rarity for you, Mr. Murad.
It is.
Probable cause February 7th in front of Judge Robbins. Preliminary examination February 10th in front of Judge Taylor. Step aside.
Thank you, Your Honor.
Marcus Alvarez.
Case number 250555851. Houston, Michigan versus Marcus Alvarez. Appearances, please.
Good afternoon, Your Honor. Samuel A. Ragdon, P23-157 on behalf of the people.
And good afternoon, Rad Murad, P83665 on behalf of Mr. Alvarez. We waive reading. Mr. Alvarez stands mute. He's been advised of his rights. We don't object to personal bond.
Court, order not guilty plea on behalf of your client. Bond recommendation from the people.
People are asking for a $5,000 personal bond.
No objection.
$5,000 personal bond, Mr. Alvarez, while his case is pending. You not to possess any handguns, firearms, or other dangerous weapons. Probable cause February 7th in front of Judge Kevin Robbins. Preliminary examination February 14th in front of Judge Giles. Step aside, please.
Thank you, Your Honor.
Thank you, Your Honor.
You're welcome.
Donaldo Chinchilla.
Hi, I remember you from this morning. All right, this is case number 250555881. Houston, Michigan versus Donaldo Chinchilla. Appearances, please.
Jennifer Douglas for the people, P72748.
And Rad Murad, P83665 on behalf of Mr. Chinchilla. We waive reading. Mr. Chinchilla stands mute. He's been advised of his rights.
On behalf of Mr. Chinchilla, I had Mr. Chinchilla this morning on a similar case with a different complaining witness. I gave him a $50,000 cash surety, I believe, with a GPS tether. Is that correct?
That's correct, Your
Yes.
Honor.
Okay. I read the allegations in this case. Mr. Murad, I'm inclined to give him the same bond, but without a tether. Response.
Could I just make argument, Judge?
Yes, you can.
I just, there's clear mental health concerns contained in both reports, coming from at least a member of his family. Unfortunately, I do believe that the court has means like a GPS tether and a personal bond, to keep him away from the complaining witnesses, which is what this court, I think, is most inclined to do. I'd ask the court to consider setting personal bond here. The court obviously knows he's not going anywhere, as the court has him held on 50,000 cash, with tether on the other matter. This is all stemming from the same facts and circumstances and allegations. I'd ask for personal bond, Judge.
Mr. Douglas, in response?
Your Honor, the people are actually asking for 100,000 cash or surety with tether house arrest on this. It's tether on the other one. It's tether in a curfew. This is different from the other in that here we have allegations of he's going to come and shoot up the restaurant, and also that he actually sent a picture of him holding a gun and that a screenshot was provided to police. So here we have a situation where he's allegedly made multiple threats, where there was a PPO that was served. In the other case, while the person had gotten the PPO, theirs hadn't been served yet. This is the one who the PPO was served and by the police at the location, and yet he allegedly is calling repeatedly and coming to that location repeatedly after being told by police he was not allowed to because he had a PPO. So, Your Honor, given the allegation that he's threatening to shoot people, that he sent a picture of himself holding a gun, and that he's been to that location multiple times after police already told him, we believe that this is an indication that an order just by itself that he will not show up is not sufficient. We don't think that a curfew with these additional allegations is sufficient. So that's why we're asking for that bond. We're asking for 100,000 cash or surety tether house arrest.
Okay, court haven't heard argument as to bond related to the matter this morning. I am going to give a $50,000 cash surety bond in this matter. No GPS tether, no contact with Teresa Ignacio, cannot possess any handguns, firearms, or other dangerous weapons. He's going to have a bond redetermination here on Monday on both matters. February 3rd, 9 a.m. in front of Chief Judge McConico. Probable cause February 12th, preliminary examination February 19th. Both in front of Judge Taylor. Is there anything else either counsel wants to put on the record?
Nothing from the people. Thank you, Your Honor.
Mark the file medical, Judge, but nothing else.
All right. Step aside, sir. Marcus file medical. What's your name? State your name again.
Devontae Lee.
All right. This is case number 250-443-2501. Houston, Michigan versus Devontae Lee. Appearances, please.
Samuel A. Ragnan for the people, Your Honor.
Ryan Marad, PA 3665. On behalf of Mr. Lee, we waive the reading. Mr. Lee stands mute. He's been advised of his rights.
Court will a not guilty plea on behalf of Mr. Lee. Bond recommendation from the people.
Well, Your Honor, he has another case that's pending that shows a 2,000 cash surety bond for his failure to appear on 1/30/25. And you were the presiding magistrate on that. But he has had a number of failures to appear on the case that's pending. This case, Your Honor, people would be satisfied with a $25,000 personal bond, and we'd also would like a tether, Your Honor, so he can make sure he shows up for court. And I'm not sure if that's workable or not, Mr. Brown.
All right, response from Mr. Murad.
Judge, he's 31, a life resident here in the state. This is a non-assaultive case. It looks like the items allegedly stolen were dish soap. Unfortunately, he's not employed, unable to post a monetary bond. A GPS tether would render him remandable. I would ask the court for personal bond here. No contact.
$25,000 personal bond. No contact with the Dollar General on Jefferson. Pretrial February 11th in front of Judge Jones. Step aside.
Thank you, Your Honor.
Thank you, Mr.
Michael Warman. Leave the bed, sir. Up on the next mic.
Michael Daniel Womack.
Are you Michael Womack?
Yes, sir.
Related to Bobby Womack?
I
Judge,
wish.
who's Bobby Womack?
You what?
Who's Bobby Womack, Judge?
You wouldn't know about it. You don't worry about it, Mr. Murad. Don't
Well,
worry about it.
You guys always do this.
He knew he knew who Bobby Womack was.
I
That's
did
all
too,
that
and so
matters.
does Miss. She knew.
I'm not gonna
All right,
make
Mr.
any.
Womack. Mr. Womack, this is case number 250-555-9101. People say the Michigan versus Michael Womack. Appearances, please.
Good afternoon, Lisa Coyle appearing on behalf of the people.
Fried Murad, PA 3665. On behalf of Mr. Womack, we waive the reading, stand mute. He's been advised of his rights.
All right, the court will enter not guilty plea on behalf of Mr. Womack. My recommendation, Mrs. Coyle.
This is non-assaultive, but the people are asking for 15,000 cash surety. He has 9 prior felonies, all theft related. He is a parole absconder. The date of absconsion was December 18th of 24. This occurred January 29th of 25. So he was absconding from parole when he picked up this case. Your Honor, and I don't know if there's a parole hold on him or not. I guess we could ask the DDC, but I'm asking for that cash surety.
What was the amount again?
15,000 cash surety with the tether.
Okay.
Judge, I'll make it
Officer
easy for
Green.
you.
Oh, go ahead, Mr. Rod.
If there's a parole hold, I won't object. If there's not a parole hold, I'd like the argument.
Okay, is there a parole hold on him, Officer Green?
Yeah.
Yes, Your Honor.
Okay.
I won't object to any bond recommended by the people.
Oh, so that's one way to cut you down, keep you quiet, huh?
Probably about the only way, Judge.
I'm sorry, Mrs. Coyle. I'm up and I'm getting distracted today. What was the cash bond you requested? You said 15?
15, yes, thank you.
15 or 50?
15.
Okay, all right. $15,000 cash surety. Can I go back to the Greenfield address where this incident allegedly occurred? And the reason for this cash bond is primarily, I believe he's a potential flight risk. He's able to post a bond, be GPS tether house arrest. Bond redetermination here will be Monday, February 3rd, in front of Chief Judge Mechanical. Probable cause February.
Sorry, Judge.
Probable cause February 11th, preliminary examination February 18th, both in front of Judge Giles. Again, I know it's a moot point, but I have to schedule bond redetermination Monday, 9 a.m. in front of Chief Judge Mechanical. Is there anything else either council wants to put on the record?
Nothing
Oh,
further,
thank you.
thank you.
Okay, step aside, Mr. Womack. Mr. Rod, once the docket's
Yes, Judge.
over, I'll give you a lesson on Bobby Womack.
Okay, sounds good, Judge.
State your name slowly, sir.
Jason Briggs.
All right, Mr. Briggs, you had some traffic matters in which you failed to appear in court for. As a result of your failure to appear, warrants for your arrest were issued. The court's going to set aside these arrest warrants. Your personal bond in each of these misdemeanor matters that carries a maximum penalty of up to 93 days in jail and or a $500 fine. You have the right to remain silent. Anything you say can and will be used against you. You have the right to an attorney. If you can't afford an attorney, one will be appointed on your behalf. The tickets are P1149515 expired plates. Ticket P1620843. Driver license suspended. Open alcohol to motor vehicle. ticket P 1149517, driver's license suspended, driver's license never required. In each of these matters, you're getting a personal bond, no dollar amount, pretrial, February 21st, in front of Judge Yancey. And on to your main matter. This is case number 250-55-59001. Pearson Michigan versus Jesse Briggs. Appearances, please.
Jennifer Douglas for the people, P72748.
Brad Murad, P83665. On behalf of Mr. Briggs, we waive the reading, stand mute. Mr. Briggs been advised of his rights.
Court on that guilty plea. On behalf of Mr. Briggs, bond recommendation from the people.
Your Honor, the people aren't going to object to a $35,000 personal bond. We would ask for no contact. Mr. Briggs is currently on parole. He's been on parole since September of 24 for attempt second-degree child abuse and felony firearm. The child in that case is the child he shares in common with this complaining witness. This set of allegations seems to involve a push and a destroying of the phone, which is not good, which is why I'm asking for that higher personal. But the case he's on parole for is actually non-assaultive. It's a unsecured weapon case where the child got hurt. So I don't actually have any assaultive history that I saw for Mr. Briggs. So I'm not going to object to $35,000 personal, but I would ask for no contact.
No objection to the recommendation. Just a comment, Your Honor. I read this report. How many times have we seen this fact pattern? A lot, and it's never charged as a felony. I want to put on the record, I do think count one is a bit of a reach to charge him with a felony with this fact pattern, but no objection to the recommendation.
Yeah, $35,000 on a personal, no contact. Does not appear. Do they live in the same house?
Not-
I believe this is the mother-in-law, Judge. I don't believe they live together.
Okay. All right, $35,000 on a personal bond, no contact. It looks like they live on the same street.
Yeah, never mind, Judge. I stand corrected. No objection to no contact.
Okay. No contact with Shamira Houston. No contact with Shamira Houston. You're not possessing any handguns, firearms, other dangerous weapons while this case is pending. Is that clear, sir?
Yes, sir.
Okay, one moment for your court dates. Public cause February 7th, preliminary examination February 13th, both in front of Judge Jack K. Step aside, please.
Thanks, Your Honor.
Step on the next mark. All right. Face the camera. Michael James Benier.
Mr. Manir, you have some traffic matters which you failed to appear in court for, sir. As a result of your failure to appear, warrant for your arrest were issued. The court's going to set aside this arrest warrants. Your personal bond is misdemeanor matter that carries a maximum penalty of up to 93 days in jail and or a $500 fine. You have the right to remain silent. Anything you say can't and will be used against you. Your right to the attorney. You can't afford an attorney. One will be appointed on your behalf. The ticket is P1152433. No insurance misdemeanor. Pretrial, February 21st, in front of Judge Michael Wagner for this ticket. Now to your main matter. This is case number 250-55-59101. Please send Ms.
I lost you.
Hold on 1 second.
Okay.
All right, I'm sorry. Paperwork issue here. Case number 250-55-589. People State of Michigan versus Michael Manir. Appearances, please.
Samuel A. Ragland for the people, Your Honor.
Rad Murad, P83665. On behalf of Mr. Manir, we waive the reading, stand mute. Mr. Manir has been advised of his rights.
Court on not guilty plea on behalf of Mr. Manir. Bond recommendation from the people.
People are asking for a $25,000 personal bond here.
No objection.
Sorry.
$25,000 personal bond.
Yeah.
Mr. Manir. Probable cause, February 7th, preliminary examination, February 14th. Both in front of Judge Jefferson. Step aside.
Say full name.
Jerron Stewart.
Okay, give me one moment. Mr. Stewart, you have some traffic matters which you failed to appear in court for. As a result of your failure to appear, warrants for your arrest were issued. The court's going to set aside these arrest warrants, give you a personal bond, and in each of these misdemeanor matters, it carries a maximum penalty of 90 days in jail and or $500 fine. You have a right to remain silent. Anything you say can and will be used against you. You have a right to an attorney. You can't afford an attorney. One will be appointed on your behalf. The ticket is P1640418. Driver's license never acquired. Pre-trial for this ticket would be March 7th in front of Judge Archer. Now to your main matter. Calling case number 250-55-59301, People City, Michigan versus Jermaine Stewart. Appearances, please.
Beverly Ragland for the people, Your Honor.
And Ryan Marat, PA 3665. On behalf of Mr. Stewart, we waive the reading. Mr. Stewart stands mute. He's been advised of his rights.
Court runner not guilty plea on behalf of your client. Bond recommendation from the people.
We're asking for a $10,000 cash surety bond. If he's able to post bond, we're asking for a Tevra home arrest. The defendant was found during a traffic stop having a gun in his vehicle. He's got 10 felony convictions, as I read this, in multiple states, 3 different states, Michigan, Alabama, and Kentucky. His last one serving 5 years for a federal drug case. He had a 5-year supervised release, and he had violations of probation on that as well. So I feel that he's a flight risk, Your Honor, since he's been convicted in multiple states, and I think that he needs to have a cash fund.
Mr. Marat.
Judge, no convictions since 2004, nothing assaultive that I saw, no combative behavior upon arrest, 5 children in the community, life resident here in the state, no capious history either, recipient of disability, non-assaultive. Again, I think personal bond is more than appropriate here.
$10,000 on a personal bond, Mr. Stewart, while this case is pending. You not possess any handguns, firearms, or other dangerous weapons. Probable cause February 7th, preliminary examination February 14th. Both in front of Judge Jefferson. Step aside, please.
Thank you.
Thank you, Your Honor.
Jonathan Sanders.
What's your name?
Jonathan Sanders.
All right, this is case number 250-55-59201. People City, Michigan versus Jonathan Sanders. Appearances, please.
Lisa Coyle appearing on behalf of the people.
And Ryan Marad, PA 3665. On behalf of Mr. Sanders, we waive the formal reading. Mr. Sanders stands mute. He's been advised of his rights.
Court will not guilty plea on behalf of Mr. Sanders. Bond recommendation from the people.
Your Honor, this is an armed robbery. I do understand that Mr. Sanders is 18 years old. I see no criminal history for Mr. Sanders. The complaint in this matter is 14 years old. I also note that the defendant has turned himself into the police. I believe his father brought him in. But what we have here are serious allegations in which he confessed to all of them. The evidence here is strong, not only the alleged statement made to the police acknowledging the robbery of his friend and by himself as well as others, but actually took full blame for it. And that he's also, there was a video posted on Instagram of him holding the gun and making those statements as well. A search warrant execution at his house turned up the headphones that were found hidden in a pizza box. Your Honor, the evidence here is strong. The people here, I do understand, yes, he did turn himself in. Yes, he does not have a criminal history, but this is a 14-year-old with a gun being pointed at him, demanding his headphones, and a Nike ski mask. So for that matter, Your Honor, it is assaultive. I believe he may be a danger to the complainant. It appears that the complainant and him know each other. This is ongoing back and forth. It appears there in the IR, there's a reference to the complainant then going to his house, going back there and causing problems. So, Your Honor, based on the safety to the complainant as well as to the community, I'm asking for a $75,000 cash surety with tether house arrest, Your Honor.
Is he remandable?
Yes, he is.
Any particular reason why you're not asking for a remand?
Because there is no I'm looking at it from a strategic point of view. I have no problem with the remand in this matter based on the ongoing things. Although I do note this court does look at him being 18 years old, having no criminal history, as well as turning himself in with his father as all positives, and they are all positives. Although I do note here that this is highly dangerous. So I have no problem if the court considers a remand. It's actually, if he was older, I would be asking for that automatically, but I do note those things for the court. So I have no objection to the court considering a remand in this matter, obviously.
Ms. Marad, I'm inclined to do a remand. Response?
Thanks, Judge. So I can tell you, Judge, on behalf of Mr. Sanders, a lot of the reasons articulated by Ms. Coyle, I mean, he turned himself in, him and his father. He doesn't have any criminal history, no pending matters, no arrests. He's still in high school. I mean, these kids are all babies, to be honest with you, Judge. I had a case just like this. There actually was a felony firearm charge attached to the case that I had, and we ended up resolving it with an unarmed robbery under HIDA, and I think 30-day county time. I don't think that there's an ongoing threat. I don't think there's an issue of ongoing violence between these parties. I think these were children, and ultimately, I know there are allegations, but it's alleged that my client, did something horrible. Now, is he somebody who needs to stay in jail for the rest of his life or while this case is pending? When we talk about bond, it's what is he going to go out and do? Is the guy who turned himself into jail with no prior history going to go out and reoffend? I don't see it here. I see a scared child who's made a horrible mistake, allegedly, and is now in a situation where he spent time in probably the scariest place in the world for him. He's going to go right back home with his father. I'm asking you to tether him to his house. Give him a fair bond. I think a personal bond with the home confinement would be appropriate here, but I feel silly asking for that if you're considering remand. But he doesn't have any priors. Nobody was really injured here. There's not an ongoing beef. These are babies. And ultimately, Mr. Sanders is facing these types of charges, and being on bond for this alone is terrifying enough to correct somebody's alleged behavior. Trust me, I've been through this process with many people. But I'd ask the court to confine him to his house on a personal bond.
Your Honor, I do look at the notes and I see the court's, I see this, that it is saying that the victim tried to firebomb the defendant's house afterwards. So a remand may actually keep the defendant safe too, as well. I'm not accusing the complainant of that, but there is, as it states in the IR, there's a video of that. So it maybe more things will be flushed out at the preliminary exam when this is held, and that it may be at the time bringing a remand keeps all parties safe. I mean, it's not a question of whether he did the allegations, the evidence is strong. I found at his house the video of him a full admission allegedly to the police, him turning himself in. That shows remorse.
Yeah, I for all the reasons stated, like there's strong evidence of guilty of the confession, and at least some videos related to this matter. And to Mr. Rod's point, 18 years old, his father turned himself in. The only question I have for you, Mr. Murad, is he still in school? You said he's still in school?
He's still in school. He's still in high school.
Is he still scheduled to graduate?
I believe so. Yes, Your Honor.
You know what? It may be, you know, as you call them, babies or young adults, but at some point, when you conduct yourself in an adult manner, you have to face adult consequences.
But everybody deserves a
And
second chance.
Everybody deserves a second chance. But
This is his first time here.
Okay, Mr. Murad,
Sorry,
out
Judge.
the room.
I know.
Okay. These allegations are very, very serious. And yes, he's 18 years old. Yes, he's in high school. But at some point in life, he's going to have to learn that there are consequences for your behavior. Now, granted, as your office likes to remind me, he is presumed innocent. But these are very, 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 very serious allegations. And I'm going to remand him under MCR 6.106 for the reasons articulated by Mrs. Coyle.
Oh, he turned himself in. Would you at least consider a bond to let Chief McConaughey go look at it?
No.
A high cash bond? I mean, what's the point of him turning
How
himself
many
in?
more times am I going to say no, Ms. Murad? No, 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 no. No, 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 no. Probable cause February 12th, preliminary examination February 18th, both in front of Judge Giles. Step aside, sir. Mr. Jones, I haven't seen you in a little while.
Gone for a couple hours.
All right, this is case number 250-5559-501, Pierce City, Michigan versus Tommy Jones. I know for the record, I arraigned Mr. Jones this morning on another related matter, and I gave him a $50,000 personal bond. Appearances, please.
Samuel A. Ragland for the people, Your Honor.
Brad Murad, P83665, on behalf of Mr. Jones. We waive the reading. Mr. Jones stands mute. He's been advised of his rights.
Court will deny guilty plea on behalf of Mr. Jones. Bond recommendation from the people.
Well, people are asking for $50,000 cash surety bond now, Your Honor. He's able to
I know
post
you are.
If you can post it, then we want to tether with home arrest. As the court can see, there's 10 charges against this defendant for basically the same things, but enhanced the number of things, times that he did this morning. This incident, he sold 2 vehicles to a man.
I know what he did.
All right, Your Honor. But I just think that it's.
So I know what he did, and
Okay. I'll
with
just
respect to
ask for
the
this
two
bond.
vehicles.
Thank you.
Okay, Mr. Murad.
So, Judge, here the court rule is very clear. You have to articulate some sort of danger to the community or flight risk, and these allegations contain neither. He has no capious history whatsoever. There's no presence of threat. There's no intention of harm, even contained in the report.
What kind of bond are you asking for, Mr. Murad?
Personal, Judge, always.
Okay, $50,000 personal bond.
Wait, what about 765.68?
And Judge, I have a response to that. This incident date is from October 30th, 2024. It actually predates the one he was arraigned on earlier. So because of that, I don't think that court rule applies.
But he's not arraigned.
It's not like he was on that personal bond and then committed this offense. I think that's when that court rule applies.
How many?
I would agree, Mr. Murad. $50,000 personal bond, probable cause February 13th, preliminary examination February 20th, both in front of Judge Taylor. Step aside, sir.
Thank you, Your Honor.
Javier Stallworth.
Javier or is it Javier?
It's Javier.
All right, this is case number 250-5559-701. Pierce City, Michigan versus Javier Stallworth. Appearances, please.
Please, Coyle appearing on behalf of the people.
Ryan Murad, PA 3665, on behalf of Mr. Stallworth, we waive reading, stand mute. Mr. Stallworth's been advised of his rights.
Not guilty plea on behalf of Mr. Stallworth, right? Excuse me,
Your Honor,
bond recommendation from the
no
people.
objection.
Excuse me.
Sorry.
No,
No objection to
no.
a $5,000 personal bond because this is non-assaultive, no criminal history that I'm aware of.
I agree,
Okay,
Judge.
my apologies. Yeah, my apologies. $5,000 personal bond, Mr. Stallworth. Probable cause February 7th in front of Judge Kevin Robbins. Criminal examination February 14th in front of Judge Giles. His case is pending. You're not to possess any handguns, firearms, or other dangerous weapons. Step aside, please.
Thank you, Your Honor.
Your Honor, I believe that's all the men. I'll meet you on the female side.
What about oh, okay, he's a walk-in. All right. See you on the female side. What happened to Jeremiah Jackson?
We never saw him, Judge.
Okay. All right. I think you knew it was Friday.
Knew he had a tough magistrate.
Oh.
I'm sorry.
I'm just somebody who doesn't know what Bobby Womack is. You don't even know who Bobby Womack is.
The Valentinos? That was his script? That was his script?
Come out over the other way. Come on over the other way. Oh, no.
Oh, I hear voices. I see no people.
Yeah, sure. I wish Miss Stevenson was here for this case, Judge.
Hello.
Hi,
Good
how are you?
evening. Good evening.
Good evening.
Hello.
Good evening. What is your
Good
name? What is your
evening.
name?
Good evening.
Hi, what's your name?
My name is Kayla Robinson. How are you today?
I am fine.
Very good. Thank you so much for taking my case today. Thank you for representing me today, sir. I appreciate you.
Of course.
I know you.
You listen, let's just focus on what's important, Mr. Burton.
No, I can't do this. I know you.
Oh, I know. And let me tell you.
Hey,
Don't tell me anything. Don't tell me anything. Just step aside, Miss Kayla. No, Miss Kayla, Miss Kayla. Step aside. I know you.
Can you sit down and be quiet?
Give me one moment, please.
Okay.
Okay, state your name, please.
Melanie Johnson. Robinson, Taylor Robinson, sorry.
All right, Ms. Johnson, this is case number 25055598001. People City, Michigan versus Martina Johnson. Appearances, please.
Jennifer Douglas for the people, P72748.
Judge, good afternoon, man. Please, this court, Philip Reagan, P57156 on behalf of Ms. Johnson. We waive the formal reading, stand mute. She's been advised of her rights.
Court will not guilty plea on behalf of Ms. Johnson. Bond recommendation from the people.
Your Honor, on Ms. Johnson, the people are asking for a 50,000 cash or surety with tether house arrest. While Ms. Johnson does not appear to have any criminal convictions on her record, the allegations here would indicate that Ms. Johnson is a danger to the public. Here we have the allegation that she went to some people who weren't even there for her house, a completely different house, which she seems to admit that they said they were there for a different house. But she is alleged to have pointed firearms at multiple people. Fortunately, this is a situation that could have ended up much worse, as the one complaining witness actually had a firearm and ended up deciding to put it down and try to de-escalate the situation. But here, the one complaining witness indicated that the defendant was irate and telling them to leave, saying that if they didn't leave, they would shoot. And Your Honor, it wasn't just these two complaining witnesses. There were workers there as well who were doing the eviction. Your Honor. And then we have that when police arrived there, they see Ms. Johnson in the street and she does have a firearm on her. So Your Honor, we have concerns for the safety of the public here. The one complaining witness said Ms. Johnson was going on about a missing 13-year-old girl, and he had no idea what she was talking about. So it's unclear what exactly would have been, would make this make sense. But Your Honor, there was a third-party witness who indicated that he saw this defendant pointing a gun at other individuals. That he corroborated that she shot a round into the air. And so, Your Honor, given that we have some individuals who apparently were not trying to be hostile, Ms. Johnson, were not even there for anything having to do with her, they had firearms pointed at them and threatened to be shot. So given that there's this danger to strangers, we think there's a danger to the public. Given that one of those complaining witnesses is the landlord for the nearby property, it is likely that he will be near there in the future as he continues to do things with the property. And so we think that this is an ongoing threat. We're asking for 50,000 cash or surety with tether house arrest.
Mr. Reagan?
Judge, I'm glad Ms. Douglas said, it doesn't make sense. Let me make it make sense. Let me make all of this make sense. So
no, I just want to know, I don't want you to make it make sense. I want your bond argument.
I'm about to give you my bond argument. It's going to make sense. So, Judge, my client lives at a residence on Grand Street. She lives in a 2-family flat. Above her, she's a landlord. Above her is the aunt of Desire Harris, who lives with her boyfriend. So the boyfriend wants to get Ms. Harris's aunt out the house because he's been getting a lot of threats and different things happening because of the case, the publicity that's going on with the case. He calls a podcast over to do a podcast that day. So this is Wednesday. So my client's also been getting a lot of threats based on the fact she hasn't put this aunt out the house and all this other stuff. So fast forward to Wednesday, she takes her daughter to school. She comes back home. There's 6 different cars sitting all around up the alley in front of her house with different men in them. I'm assuming it's the whole armor squatter removal, whatever that is, Judge. I have to what the whole armor squatter removal. I guess people feel like they can just remove people if they think they're squatter. Regardless, Judge. So what happens? My client's a licensed CPL holder, has her gun on her hip. Never once takes the gun off her hip. Never once. She starts to ask the people that are sitting in front of her house. There's several cars. What are you guys out here doing? They start to get aggressive. She calls the police. My client does. They come out, right? never find any shell casing anywhere on the ground because she never removed the gun off her hip. In fact, they took the gun off her holsters. That's how they removed it. It was on her hip. Still had one round in the chamber. She never shot the gun. These guys had to get their story together. They all came up with the same story saying, oh, she pointed a gun at us, just so they could get her locked up. She's been getting threats, Judge, based on this other cases going on. She has a license to carry guns. She never shot it one time. I'm asking for a personal bond, for her. I don't think she's a threat. I think this is all made up. I sat here and listened for an hour, and it all made sense. It all made sense, Judge. And I'm just asking you to take my bond argument into consideration when setting bond, Your Honor.
And Your Honor, if hers was the only house on the street, it could make sense. But when you have a residential block, people might be there for other houses, and that's what they indicated. So, Your Honor, there's a third-party witness who says this also happened. It's not just these complaining witnesses.
Don't say that.
Hold on. One moment. Okay, one moment.
I've never raised somebody in church. So I mean, he was moaning and not, that was my thank you in the church.
Oh. Okay, go ahead with your argument as to bond. Mr. Reagan, you bring up some good points. Whenever I look at these type of matters, the various factors I look at. One, where the incident occurred. Two, one of the factors that points to your client's favor is she's a CPL holder. And three, an argument could be made that she was arguably acting in self-defense. The report indicates she fired and shot in the air, and I can understand being a woman by yourself, seeing gentlemen and people around the house, you can be fearful. And I'm like, for her safety, I get it. That's why she's probably a CPL holder. And like I said, both witnesses say the defendant fired one round in the air during the verbal altercation, which means she could have shot it at somebody, which means she meant business. So I'm going to give her $100,000 personal bond in this matter. While this case is pending, ma'am, you're not to possess any handguns, firearms, or other dangerous weapons. No contact with Anthony Jones nor Anthony Pollard. Probable cause February 11th, preliminary examination February 18th, both in front of Judge Jefferson. Step aside.
Your Honor, I would just, for the record, I would note that after Mr. Reagan said that thing about the 911 call, I just checked the CAD notes. The only call I see is from a gentleman named Ronald or Rold. I don't see one from the complaining witness. I mean, from the defendant. So I just want to put that on the record.
Okay, duly noted. Step aside. You can bring back Kayla Robinson. Huh?
Hello.
Oh. Give me 1 second. All right. Recalling Kayla Robinson. I just want to put this on the record. I've known Kayla Robinson for several years. I had the privilege of her voting for me this past November. She has a beautiful voice, and I'm going to recuse myself because I know her personally. Magistrate Delphia Burton will be handling this.
Thank you, Mr. Burton. I appreciate you.
Okay, good afternoon, everyone.
Good afternoon, Your Honor.
Yes, good afternoon, Ms. Robinson.
Good afternoon, Your
Okay,
Honor.
call.
How are you today?
I'm well, thank you. Calling case number 25-055-587-01-FH. People of the state of Michigan versus Kayla Elise Tanai Robinson.
Kayla Elise Tanai Robinson.
Elise Tanai, I'm sorry, Tanai Robinson. I stand corrected. Appearances, please.
I'm sorry.
Don't say anything
appearances,
else, Ms.
please.
Robinson.
Lisa Coyle, appearing on behalf of the people.
And Ryan Murad, PA 3665 on behalf of Ms. Robinson. We waive the formal reading. Ms. Robinson stands mute. She's been advised of her rights.
Okay, I'll enter a not guilty plea on behalf of Ms. Robinson, as it relates to bond, Ms. Coyle.
Your Honor, people are asking for a 5,010%, no contact with the complainant is denoted in this matter, or the 8438 Harper address. Apparently, the only thing I see under criminal history is the home invasion first from 2015 under HIDTA status. She admitted to pepper spraying the complainant in the face and the head. She went to the precinct and turned herself in and admitted everything. Apparently, this is
Ma'am, hey, it's really important, Ms. Robinson. It's really important that you let the prosecutor finish. We all just have to do our jobs, even if you disagree, okay?
Okay.
In this matter, Your Honor, the complainant knows the defendant from the church, Ms. Edwards, who was the door that we're talking about. Ms. Robinson was allegedly in a relationship with Ms. Edwards' son, and she began then stalking Ms. Edwards and her son at the church. So for these reasons, Your Honor, I believe, based on the fact that she actually discharged this pepper spray, admitted to everything, she does pose a danger to Ms. Denard, as well as others. So I'm asking for that 5,010% with no contact, Your Honor.
Okay, I have some questions.
Oh, sorry.
Oh, go ahead. Yeah, you can go ahead.
So on behalf of Ms. Robinson, Your Honor, I'm aware that I agree with Ms. Coyle. I didn't see anything on her record at all. I'm not aware of the priors. I acknowledge the prior that Ms. Coyle put on the record. There are no pending matters against her. There is no probation. There's no parole. She has a few different jobs that she does, but none of them are the most profitable. She actually works with certain nonprofits as a grant writer. She also engages in her neighborhood safety patrol program, and she's also a musician. She cannot afford any money, Your Honor. She has a stable residence with her mother. You know, her side of the story, of course, as the court knows, is always going to be a little different. It's her position that she actually never got out of her car, that this altercation took place while she was actually still in her car, that she drove to the police station after, trying to tell her account as to why the pepper spray was discharged. But that resulted in her being charged, coupled with the complaining witness's statement. She understands not to go near that church. She understands not to have contact with the complainant. She knows how serious this now has become. I'm asking for a chance, Judge. Given her ties to the community, lack of KPS history, lack of any criminal history in the last 10 years. I know that she's helped on campaigns, I've heard. So she seems like someone who's going to follow your orders. So if you tell her to not have any contact, I think she's going to do just that. Ultimately, I'm asking you to release her on personal bond with no contact and no pepper spray, obviously.
So I have a question for defense counsel. Ms. Robinson and the complaining witness, are they still attending the same church?
No, Miss Robinson's not going to be going near that church anymore. She understands that. She used to be a member of that church, but now she's not going to be one anymore.
Okay, the court having heard the arguments of counsel. Ms. Coy, I'm not gonna impose a cash bond. I'm gonna set a personal bond in the amount of $50,000. And Ms. Robinson, ma'am, while you're on bond, you're not to have any contact with Tabitha Ann Denard.
Yes,
nor are
ma'am.
you to engage in any assaultive behavior. You understand those conditions, ma'am?
Yes, ma'am. Can I say something for the record?
No, because the best thing that can happen is personal bond, and you just got one. Okay, so anything you say could only hurt you from here.
Thank you.
Okay, so Ms. Robinson, you have 2 court dates. Your probable cause conference is scheduled for February the 7th, 2025 at 8:30. That will be by Zoom. You also have the right to a preliminary examination. That is scheduled for February the 14th, 2025 at 8:30. Both of those matters will be before Judge Jefferson. Your matter on the 14th, though, will be in person, and your matter on the 7th will be by Zoom. Do you understand your court dates?
Yes, ma'am. I believe that, you said the 7th at 8:30 and the 14th at 8:30?
Yes,
One,
that's
the
correct,
first
ma'am.
one on the 7th is, Zoom, and the second one, which is the preliminary, is in person? Yes, ma'am, I
Correct.
understand.
Okay, is there anything further from, you, Ms. Coyle?
Nothing further, thank you.
Okay, how about
Nothing
you,
further, Your Honor.
Ms. Barad?
Nothing
Thank you,
further.
then we're done, Ms. Robinson. You can step aside.
Thank you so much.
Thank you, and have a great day.
Thank you, all have a beautiful day, many blessings.
Yes.
Ms. Passmore?
You want to be the last
Oh,
one?
we decided. I can.
Okay. What bond did you get? Okay, just sign it over my name. Magistrate Duffield Burton will be handling Passmore.
Hi.
Okay, go ahead.
Okay. Okay, Ms. Passmore, good afternoon, ma'am.
Good afternoon.
Okay, calling case number 25-05559401 FH, People of the State of Michigan versus Shatara Denise Passmore, also known as Shatara Passmore. Appearances, please. Who's appearing for the people? Is this?
I can't hear you.
Philip Brady
One
on
moment,
behalf of the passport, Your Honor, waive the former Regent stand mute. She's been advised of her rights.
Okay, hold on a moment. Mr. Who's handling Ms. Passmore for the prosecution?
So Your Honor, Jennifer Douglas for the people, P72748.
Okay, good afternoon.
Good afternoon.
Okay, Mr. Reagan has already indicated that his client stands mute. The court will enter a not guilty plea on behalf of Ms. Passmore. What do the people have to say about bond?
Your Honor, for Ms. Passmore, the people do have concern for safety. However, we do believe that if there's a tethered house arrest, that this is something that could address safety concerns. It's charged as assault with intent to rob rather than robbery or for some reason. But Your Honor, at this time, we would ask for tethered house arrest and then the high personal bond.
Judge, she
Okay.
doesn't have any criminal history. She's no pending cases, to my knowledge. She's on Social Security income, Your Honor. Has grown children, lives in the city. I don't think a tether is necessary in this case, Judge. I just think no contact would be appropriate. I would know that the parties are known to each other. So, I am asking for a personal bond, Judge, no contact. I think this happened allegedly at a gas station, a Sunoco station, when the parties ran into each other. And my client knows the complainant, I guess, from her house or her apartment complex, where the complainant constantly breaks into my client's house and takes things. So she doesn't really want to have contact with this complaint, Judge. She's going to avoid. I explained to her, please avoid her at all costs. I think that's important, Judge.
Your Honor, they're supposed to be living in the same apartment complex. We believe that there's not an allegation that there was a weapon used besides her nails. And so if it was a different sort of situation, we'd be asking for something else. But if there was a tether house arrest to a different location, to a different building, we believe that would ensure the safety of this complaining witness.
Well, Judge, I think.
Okay,
I'm sorry, Your Honor. I'm sorry, Your Honor.
No, I was gonna say, let me hear from you regarding
I think all the rage may have gotten out that day, Judge, when my client saw the complaint at the gas station, inquired about money that she had stolen from my client's apartment. Complaint said, "Hey, okay, I'll be right back. Let me go in the gas station." My client said, "Okay," waited patiently for her to come out. The minute the complaint comes out, she starts swinging at my client, sucker swinging at my client, and the rest happened after that, Judge. When you attack somebody, then you have to deal with what happens after. So my point is, my client I think may have gotten it all out that day, Judge. The complaint came in my client. She doesn't want to have contact. If you tell her don't have contact, she's not going to have contact with you.
Okay, Mr. Reagan, is your client working?
Does she receive Social Security income? She is not.
And how long have the parties known one another?
Judge, they live in the apartment. How long do you know this lady, Miss Passmore, or do you just know her from seeing her breaking it? Well, do you know her? She just you see her around the apartment?
Yes, I see around the apartment.
Yeah, so you don't know her.
Yeah, around the apartment.
And Your Honor, that's my
Okay.
that's my understanding that they
You use the
just
same-
recognize each
Oh,
other,
go ahead.
that they just recognize each other in passing because they live in the same apartment, but they don't know each other.
Okay. And do they use the same entrance?
Can you use a separate entrance? Can you use a separate entrance? Oh, okay. It's two entrances there. But not really. Okay. So you need to use the back one. So use the back entrance.
Your Honor, we don't know which entrance if this was like a duplex, it would be one thing, but this has, well, you can see, I won't say the unit numbers, but this appears to be a multi-unit complex. So we can't say for sure, like if with a duplex, one person is always going to be going in the one door to access their apartment, and the other person can just always go in the other door. This is a situation where it's a multi-unit location. And so unlike with the duplex, I don't think you can say you can just keep going to the building, just use a different entrance.
I understand Ms. Douglas' point very well, Judge, but that's why I maybe asked for no assaultive contact, because there are reasons why things happen. If you don't break in my house, I don't have to check you about it, and we may not get into an altercation. I do understand in normal situations, there are reasons why people react to stuff, and I'm not saying it's right or wrong. I'm just saying just because you get charged shouldn't mean you have to not go back to your house because somebody else does something to you. But I know what Ms. Douglas is saying. I get her point about it, Judge, but I just think no assaultive contact maybe. So, don't say nothing to her, go the other way. But, this wasn't just a random situation where my client said, let me just go up to this lady just because she's a neighbor and start to hit her. That wasn't the situation.
Okay, the court has heard arguments, and I'm certain that there are two sides to every story. But it doesn't appear that, I don't know, are these on separate floors in the building? There's one, I see one apartment is E and the other apartment is B. So would they be on different floors at least?
I know my client lives, oh, okay.
They are on different floors. Okay. I'm not gonna impose a tether. The court will set bond at $75,000 personal. Ms. Passmore, you're to have no contact. That means no contact, you yourself or by a third party, anybody else in the building. No email, don't text, don't send any messages by anyone to the complaining witness, Ms. Barclay. You understand that, ma'am?
Yes.
Okay, and you're not to engage in any assaultive behavior while this case is pending. Are you clear as it relates to that?
Yes.
Okay. You have two court dates. You have a probable cause conference that's scheduled for February the 13th at 8:30. That will be by Zoom before Judge Taylor. You are also entitled to a preliminary examination that will be conducted in person on February the 20th at 8:30. That will also be before Judge Taylor. Ma'am, do you understand your court date and do you understand the conditions a bond. I don't know if I said no contact with Katie Barclay, but I'm reiterating that, restating that. You understand?
Okay. Yeah.
Okay. All right, do the people have anything further?
Your Honor, if I knew there wasn't gonna be a teller, I would have asked for a money bond, but, I understand the court's ruling.
Do Ray get anything further?
Nothing further, Your Honor.
Okay. Ms. Robinson, man, we're done. You can step aside and have a good day.
All right, that concludes the docket. Have a good weekend, everybody.
Do the same. Thank you.
Take care. Thank you.
All
Have a
right.
great-
Good weekend, everybody.